So on that topic, what should someone's in a self-defense incident and whatever happens goes down and now they defended themselves and the cops are coming or they need to call the cops. What should happen the minute like, okay, I've just had it, I'm safe, the incident's resolved. What should I do?
A little dependent on the situation, but
Okay.
if it's a self-defense situation, ideally if someone else is there with you, normally we would encourage that person to call law enforcement and report that. For example, maybe if it was a self-defense situation involving a firearm, if they can just report that there was a shooting. And not give, significant other details. Or if you have to call yourself, you can report it to law enforcement, especially if the person needs aid. The priority is making sure that you're safe in that situation. But it's also, you may be in a situation where you need the officer's help to further protect you or provide the person that was shot aid. So if you're the person that has to call 911, normally we do think it's fine to do so. Just keep it very general. Just say, call 911 and say there was a shooting. So that's all they need to know. You don't have to admit to the shooting. If the operator presses you for details, it might feel a little awkward, but you just want to stand firm in saying there was a shooting and give them the place to respond. But after the incident, there's probably a few things you need to do first, depending on the situation, before you even take that step of calling 911. The two things I always try to just drill into people's head. I already said one of them, just shut up, but the other one is make sure you don't get shot. And that can be first from the person, your assailant. Maybe they had a weapon as well. So you want to make sure that, your assailant is not able to continue to harm you in some way. That could be as simple as you fleeing to safety, going to another location. That could be if that person is incapacitated after the self-defense situation. That could be making sure the firearm is removed from their vicinity or their weapon is removed from their vicinity where they can't reach it and continue to harm you. Something like that. So you want to make sure that you're not going to get attacked by your assailant any further. After that, you have to, that's when you might call 911, and you need to be prepared for when officers show up for you not to get shot. You're going to tell them there was a shooting, but even if the officer knew that you were the person acting in self-defense and they knew the other person was the assailant, that might not be immediately clear to them by the time they, respond to the scene. They're not going to necessarily know what you look like or what the assailant looks like, or there may be multiple people on the scene. Officers are knowing they're going to go into a potentially dangerous situation at that point. So they're going to have weapons on them, and you want to make sure that you're acting safely to where the officer doesn't determine you to be a threat either. So that means that if you used your firearm in self-defense, for example, it may be wise to move your firearm to a location, again, where you need to make sure your assailant's not going to reach it, but where the officer doesn't respond to the scene and see you holding a firearm in your hand. That may make them feel like they're at risk at that point. So you want to make sure your firearm isn't necessarily in your hand where it's threatening to an officer. Of course, if there's some reason for defense purposes that you need to hold on to the firearm, that's different. But in most cases, you'll want to, make sure your firearm is no longer in your hand. You want to make sure when officers respond that they can see your hands, make sure that you're not the assailant, that there's nothing in your hands that could lead them to take action against you. And you want to be prepared to follow any instructions of the officers. You want to be prepared for the fact that when officers come, they might, get over a megaphone if you're inside your house and order you outside of the house with your hands up in a certain way. You want to be prepared for them to enter your house and, respond in that way. Just keeping in mind that it's important to follow officer instructions. And if there's an officer instruction that you think is intrusive or unfair, the time to challenge it is not in the moment when the officer is responding to the situation. There's a lot of people that, like, for example, with search warrants, no one loves a search warrant, and people say, "Oh, do I have to really comply with a search warrant when an officer shows up with one?" Yes,
Yeah,
you
you do.
do. And there's the chance that might be a terrible search warrant. But the good news is there's remedies for that. If an officer comes and serves a terrible search warrant at your house, we're able to challenge that after the fact. So it's just really important in that moment to be ready to follow officer instructions as well.
Okay, so officers show up, you've put your gun in a place where it's not within your reach, so you're safe, you have your hands up. What next?
So at that point, officers are probably going to continue their investigation. They're probably going to have an idea of what happened, depending on the state of the assailant, depending on your state. They're probably going to just, without even having to ask you questions, probably have a sense of what happened. But at that point, an officer is probably going to try to question you. That's where, again, you have to stand firm with that just shut up mentality. It's going to feel really tempting to speak to officers. And something I like to remind people is that officers are allowed to lie or mislead you in a questioning situation. For example, an officer is allowed, if they were to question you and say, hey, there was video of the whole situation. We know what happened. You can tell us. They're allowed to say that even if there was no video taken. So people need to be prepared that even when an officer might sound like they're on your side, they may not be. And so you just need to be in that mental state of, I'm not making any statements right now, even when it feels a little weird, awkward, not right. I often recommend to people that when an officer responds to call me. And try to be on the phone when the officer responds. It's possible the officer might ask you to get off the phone, but something I'll recommend is asking the officer if they'd be willing to speak with me. So if you call me in your self-defense situation, the officer responds, and then you inform the officer, hi, my attorney is on the phone. Sometimes we encourage the clients to pass the phone over to the officer, and sometimes officers are willing to give me an assessment of the situation right then and there. I'm able to get a sense for what the officer is feeling in that situation, what they think happens. And that will give me a better idea of if we want to make any statements or not. Because just because I say just shut up initially doesn't mean that it means just shut up the whole entire case. There might be a time where we decide to make a statement to an officer based on what we've gathered. Sometimes, for example, we might send investigators to the scene through our program. So if we get a call and the scene is still active, we're able to actually send our own investigator to the scene to potentially interview people, collect, take photographs, things like that. That could be helpful in the case as well. So sometimes we might be able to speak with our investigator and find some evidence that might help the case that we disclose. So really, in that initial stage, I say, continue the just shut up mentality. But if you have the option to have me listen in when the officer is responding and have the option to even allow me to speak with the officer, that's great. And that can be really helpful for a case.
Now, I've heard people mention that you should always ask to go to the hospital. Have you heard that? What's that about?
So I've heard a little bit about that, the always ask to go to the hospital.
Is that to buy you time? Is that to clear your head, to let things settle down? Or is there something there with that?
There's a lot of different reasons I think people do that for different types of cases. I think sometimes people want to, like you said, have time to clear their head, but also I think some people think it gives them the ability to argue that they were the one being aggressed upon if they need, medical attention. It's not something I advise people to do unless they actually need medical attention, for a couple reasons. One, I can't ethically advise someone to do something that's not truthful.
Right.
The second reason, and maybe more important, is that if you're asking to go to the hospital and it's kind of obvious it's a BS reason that you're asking to go to the hospital, that's something an officer might make note of in their report. So I've seen reports before where someone's asked to go to the hospital, and the officer basically writes it in a way where like saying this person showed no signs of distress, asked to go to the
Yeah.
hospital, could not provide a reason why, went to the hospital, and there was, no treatment, provided to the person. And suddenly you've put yourself in a place where you just look not credible. So I think there are times where it's definitely good to ask to go to the hospital after these types of encounters. Maybe you do need medical attention. In that case, definitely ask to go to the hospital. But I personally don't love the just blanket decision
Right.
to go to the hospital. And again, that's something if you call into our, service, it might be something we might be able to, talk through with you in the moment. But typically if it's just for the purpose of, if it's not for the reason that you actually need medical attention, I don't recommend it.
Now, if it's a you have a self-defense incident,
Mhm.
police show up, how often, especially with it being sort of a self-defense thing rather than, you just went up and blast somebody, how often will you be put into custody there versus maybe later? How does that work?
That's completely dependent on the situation,
Okay.
and where you live, and what type of incident it is. If it's a minor self-defense case, like let's say it's a self-defense case that doesn't even involve a firearm, if it's something related to like you were just using your fists to defend yourself, there's times I've seen people just cited and released on the spot. If the officer like suspects like an assault occurred, they might just cite and release you. Sometimes they might take you into the station, print you, and then just release you after that. But if there's a self-defense situation involving a shooting, it's pretty often that officers will at least take you into custody while they're investigating. And often officers, in most states, there's some sort of time limit regarding how long officers can hold you until without bringing a charge, for example.
Mhm.
And the benefit is if it's a situation where you haven't made any statements, and the evidence does not clearly show any sort of maliciousness in the reason you maybe shot or attacked another person, at that point, it's unlikely that the officer will have probable cause, to arrest you. And so if you've kind of stood firm and not making any statements, there's a good chance that while you may be in custody for a little bit, officers will be able to release you after a certain amount of time because their investigation hasn't shown any foul play or not. There's always the chance, though, that officers may get some evidence that might change their mind, where they might come back with a search warrant, an arrest warrant. There's also the chance that, again, in some of the more minor incidents, that you might be released without charges, and then a summons comes in the mail a few weeks or months later, summoning you to court for like a misdemeanor assault. Something like that can happen. So there's actually a lot of different possibilities. The most extreme possibility would be that an officer responds, thinks that you acted improperly, arrests you, and then takes you to jail. And that's, in that situation, if you're taken to jail, you'd eventually have an initial appearance in front of a judge. That is in most states within 24 hours, but sometimes it can be a little further out. Often like holidays, weekends aren't included in that calculation depending on where you live. So in some places, I think there are a couple states that are a little bit longer, that they can hold you before an initial appearance, but eventually you'll get to go in front of a judge. And the initial appearance is another thing that can kind of go a couple different ways. The ideal way that it goes for you is that the judge realizes that you're not a threat to society. While they might say, okay, well, you're facing this serious charge, but we believe you that you're going to respond. You're going to come back to court. They might release you without a bond. And you're able to go on your way. Sometimes they might release you without a bond, but they give you some release conditions, like you're not allowed to leave the state, or maybe you'll have a GPS monitor, for example. Other times a judge might set a bond. Maybe they do think you're a big threat, a flight risk, for example, and they set a bond in your case. Bonds can be a secured bond where to be released, you're only required to post like 10% of the total cost. Other bonds are cash bonds where you have to post the full amount. So if it's a self-defense situation involving a firearm, these can be some of the more serious charges, and you can see some high bonds in some states. If they're like if they've accused you of murder, for example, that could be $1 million cash bond. And in even some states, there isn't even the option to be bonded out, where you might just have to sit in jail while the case is ongoing. If you're not able to post your bond, then you'll definitely be stuck in jail, while the case is ongoing. And that's kind of another thing that our program provides that I think it really can help people be prepared for these types of situations, is that we offer some bond payment. So we offer bond coverage up to a certain amount. So if you're in a situation where you have to defend yourself and then you're taken into custody, have a bond set, we'll be able to post the bond so that you can be released.
Do you know what that amount is off the top of your head?
I believe it's 50,000, but I can pull up our fee agreement actually, so I can say for sure.
And is that like what you would post, or is that, because it's usually 10%, right? Like you have to have 10% cash.
Yeah, that's typically when I was saying there was the secured bond versus
Okay.
the cash bond. Either can be set in your case. So most commonly, in cases, it's a secured bond where you would only have to pay 10% in that situation. So let me check the bond. Okay, yeah. So for bonds, it would be a payment of up to 50,000. So for example, that would cover you for up to a $500,000 secured bond. So if they set a 500,000 secured bond, we'd be able to bond you out with the 50,000.
Nice. Okay. How long? So if you end up going to trial, and you just see it, there's jurisdiction to jurisdiction, things change. And, I look at the Daniel Penny case right now in New York City, where he's jammed up. What kind of length of time does a trial take?
So
maybe, I mean, not just the courtroom, I guess the whole process. What are you looking at?
So I'll give you another one of the classic lawyer answer of it depends. But, it's our catchphrase.
Yeah.
But for trial situations, again, kind of starting with the lowest level, in a self-defense situation, you could be charged with a misdemeanor. So a misdemeanor are in most states are crimes that are punishable with like less than a year of jail, for example. So it's not anything you could go to prison over. But there are still some potential, monetary penalties, probation penalties, jail penalties available in those types of cases. For most misdemeanor cases, they run a shorter timeline because they're less serious. There's less evidence usually to exchange in a misdemeanor case. Most misdemeanor cases are over within a few months. So usually you're in it for, I'll say, at least 3. But it can sometimes be the better part of a year. It can be like 3 to 7 months, I would say. Okay. 7 months being like a longer period of time that you're engaging in the case. And most of the time on a misdemeanor case, there's not a ton that you, as the person facing the charge, actually have to be doing. Your attorney usually takes care of most of it. For example, in a lot of states, Arizona included, we're actually able to get people's appearances waived at their pretrial conferences. So the defendant doesn't even have to show up to the pretrial conference. It can just be me and the prosecutor and the judge talking about the case. And then trials for misdemeanors are often pretty short. There are some, misdemeanor cases that can be tried in a couple hours. So, it just takes an afternoon to try the case. Other misdemeanor cases can take a couple days. But most of them are kind of 1 day or less. Felonies are where you kind of get into a whole different ball game. In most states, there's levels to your felonies, and with self-defense situations, you could be charged with like a different class of felony. So in Arizona, for example, class 1 felonies are the most serious type. That'd be something like murder. But then there's aggravated assaults that can be charged as class 3, as class 6 felonies being the lowest type, where you're really not facing as high of a risk. Maybe it's possible you get prison time, but it's only a few years. So the more serious a case is, the more likely the case is going to go on longer. So murder cases, typically go on for at least a year. Often to like a 2-year mark. It's not unusual for it to be 2 years that you're working on a murder case before you even go to trial. It kind of takes a lot of endurance to get through those cases. And then murder trials are often set for a few weeks. So, and then with the potential to go even longer than it's set. So it's often that like a murder trial set for like 3 weeks. But some more extensive murder trials can go well beyond that. So you can be in it for the long haul if you're facing a murder charge and you choose to go to trial. So that's, again, kind of circling back to why it's so important, in that initial, self-defense situation, to make sure that that's the best option in that moment, because even if it's a good shoot, this is potentially, what you're risking down the line.
What class of self-defense, like what would be some incidents where it would just be a misdemeanor as opposed to a felony?
So misdemeanors are typically would occur if it doesn't involve a weapon, for example. So an assault case is something you could be charged. Assault is something you could be charged with if it's self-defense, but it didn't involve a weapon, if it just involved your fist. Or like a disorderly conduct is something that they might tack on where they're like, oh, that guy's just being a little bit rowdy in a self-defense situation. The more serious types of crimes you can be charged with in self-defense, commonly we see as aggravated assault. Aggravated assault is often charged when you might pull out a weapon, but not actually use it. So if you point it at someone and you feel like pointing it is sufficient to diffuse the situation, that's where they might charge aggravated assault. Many states, including Arizona, have something called defensive display of a firearm. That's where you can kind of like gesture to your firearm while it's holstered, or hold it in your hand without pointing at someone. And that could be considered a defensive display, where basically you're making someone aware of the firearm with the intent to defuse the situation. And that's a really good defense that we're able to assert in many aggravated assault cases. However, again, it's something that I've seen prosecutors really disagree with. They might interpret the defensive display statute way differently than I would. And it's something that, courts have even come out with case law where they debate what the statute really means and what it extends to. And there's this exception to the statute that says you can't use defensive display in furtherance of a crime. So, for example, you can't use defensive display to commit aggravated assault. So now you're in a weird situation where you're charged with aggravated assault and your defense is defensive display, but there's the exception that says you can't use defensive display for aggravated assault. So it's a really weird contradictory law that often ends in a lot of like motions and back and forth between the prosecutor and defense. So that's kind of another like kind of weird practical thing about it. And then other than aggravated assault, I would say some degree of a murder case, maybe a manslaughter, is kind of common that you might be charged with in a self-defense situation. So there's a lot of potential charges available to prosecutors or officers when a self-defense situation has occurred. Our goal, though, is, no matter what you're charged with, we're going to try to make the prosecutor see the light and see that, this was a self-defense situation. Sometimes, there's cases where it gets charged, and, that's a scary situation just to have the case charged. But as long as we,
Sure.
present the evidence, we can convince them it was self-defense without even having to go to trial.
Right.